Peace, everybody. Peace. This is King L. Bay, bringing you some short takes. We're going to call these short takes. I'm finna start a new series of short takes. These are short take videos that's going to teach you how to understand certain processes as it's dealing with evidence. So the first thing today, we must talk about the evidentiary standard. So let's jump right into it so we can understand what we're doing when we're dealing with a lot of these records, especially the birth certificate. Okay, what is the evidentiary standard? In civil cases, the evidentiary standard may be either preponderance of evidence or clear and convincing evidence. In criminal cases, the evidentiary standards are proof beyond a reasonable doubt. This is the standard of evidence that is being weighed. So you have to understand when you're dealing in the process that you must understand it has to be, we dealing with proof. See that word, proof beyond a reasonable doubt. It's dealing with proof. Okay? They want to convince you. Remember, I told you before that it's all civil. It's all civil, and they have 3 jurisdictions. And I want you to understand there's only admiralty, common law, and equity. So let's go right to the Constitution that depict these 3 elements. Judicial power of the United States shall not be construed to extend to any suit in law. No, that's the wrong one. Let's go here. Article 2, Section 3 of the Constitution. Article 2, Section 3. Article 3, Section 2, I'm sorry. Judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. To cases affecting ambassadors, other public ministers, and councils. I want y'all to understand this. It says, to all cases affecting ambassadors, other public ministers, and councils. Okay? To all cases of admiralty in maritime jurisdictions, to controversies which the United States shall be a party, to controversies between 2 or more states, okay? Between a state and a citizen of another state, between citizens of different states, between citizens of the same state, claiming land grants or of different states, and between a state and citizens and foreign states and citizens or subjects. So, I want you to keep this in mind right here. This right here, right? I want you to keep in mind their authority to all cases affecting ambassadors, other public ministers, and councils. Okay? This is very important. This is very, very important to all cases affecting ambassadors, other public ministers, and councils. Right? So it says the judicial power shall extend in all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers, and councils. So, when we do these short takes, I'm going to break some of this down because a lot of y'all are arguing. They only have 3 jurisdictions. They have admiralty, common law, and then they have equity. But you are a special class. Once I show you this, as it relates to this, you are considered a special class. So this is a different standard of operation of law. When you come under here, under section 2, a lot of people miss this. So I'm going to show you how when we do this, you come in under this class where you're a protected class. Okay? Now let's go to here, Amendment 11. Judicial powers of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by a citizen of another state or by citizens or subjects of a foreign state. This right here affects Article 3, Section 2, what we were looking at. So if you're a citizen, you cannot bring a claim. You cannot bring a claim. So understanding this. So as we go back to this status, right? This is the status that you want to be in right here. Right? This is the status that you want to be in right here under this status. And you need to understand, this is what we're working on with King L. Bay. This is the status that you want to be in. They tell you how to do it. It's just a lot of people got to catch it. So let's continue. Let's continue, family. Let's continue. Right? So levels of proof. No evidence, okay? No evidence, meaning no trace of evidence whatsoever. They call it scintilla. Not guilty, any evidence at all, even the smallest measurable amount of evidence that says not guilty. Reasonable suspicion should be based on a specific or particular facts, reasons, not based on hunch or guess. Not guilty. Probable cause, reason, and trustworthy information that particular person has committed as a particular crime. Okay? Preponderance of evidence. The greater weight or amount of evidence, clear convincing evidence, right? All of these facts, okay? The only one you have to reach this, right? Clear convincing evidence, a firm belief, the firm belief that the allegations are true and reasonable doubt. This is where you get guilty. You have to meet this standard in criminal cases, and there has to be evidence. And everything starts with three levels. Everything comes in threes. So you got to remember is standing, right? Venue, then jurisdiction. That's how it works. Standing, you first got to have legal standing. Then you got to have venue, proper venue. Got to be in the right court to hear the matter. And then it must be, I'm tripping. Standing, venue, and jurisdiction. Those are the three elements. Then it comes jurisdiction. You gotta have the proper venue to have the proper jurisdiction. So let's continue to go. I'm trying to make these videos real short. Now, this is dealing with the evidentiary standard under Department of Health and Human Services. I want you to understand, I want you to read into this as it relates to evidentiary standard relating to misconduct. When you're dealing with standards of proof, when dealing with institutions for as medical records or certain types of records. So this thing can be reversed when certain evidence is not presented. So a lot of you, when we trying to get the birth certificate right, the affidavit that was filled out by your mom and dad, they don't have it. They won't give it to you. Right? So you can use and reverse this same standard of practice on them when looking at the application. So evidentiary standard. The following evidentiary standard apply to findings made under this part. Standards of proof. Okay? An institution or the Human Health Services findings of research misconduct must be proven by a preponderance of evidence. They tell you the evidentiary standard. Okay? Burdens of proof. The institution or HHS has the burden of proof for making a finding of research misconduct. The destruction, absence of, or respondent failure to provide research records adequately documented. The question research is evidence of research misconduct where an institution or HHS established by a preponderance of evidence that the respondent intentionally, remember I told y'all intent, everything started with intent, knowingly or recklessly had research records and destroyed them and had the opportunity to maintain those records but did not do so, or maintain the records and failed to produce them in a manner that the respondent conduct constitute a significant departure from the accepted practice of the relevant research community. So what you got to understand, right? Everybody trying to get their affidavit that their mother signed as the informant. So guess what happens, family? They don't got it. So what do you need to do? You can reconstruct because you have first-hand knowledge. And since they don't have it and then you request for it, you got to request for it. And you got burden of proof that they don't have it, then they had a responsibility to maintain the record. Okay, peace. So let's get back to it. Family, respondent has the burden of going forward with the burden of proving. Girl, what are you doing? By a preponderance of evidence, any and all affirmative defenses raised, and determining whether the HHS or institution had carried the burden of proof imposed by this part. The finding of fact shall give due consideration, admissible, credible evidence, and honest error or difference of opinion presented by the respondent. So I want y'all to understand. Y'all got to understand how to relate and make your cases stick. You got to learn how to be holding all the cards. This is poker. Got to go in there. That judge got on his poker face. This is a game of poker. Thanks, Tim. I like that. I'm giving Tim a shout out. This is a game of poker, family. So I want people to understand what we're doing here as it relates to this information and how we're going to drop this, right? So the judge has his poker face on, the prosecutor has his poker face on, but you holding all the cards. Let's go. The respondent has the burden of going forward with proving by a preponderance of evidence any mitigating facts that are relevant to a decision to impose administrative action for following a research misconduct. So we're not claiming that they're doing is misconduct. We're claiming that these records are, if they don't have it, they've been lost or destroyed. So the only person who has first-hand knowledge is you. Most of those people who think they have first-hand knowledge, they're either dead when you were born or they're doing something else. And they've been doing this for a long time. They probably can't account for no first-hand knowledge of your affidavit. So you have the right to restore your status the way you want to without any interruptions from any other party because you have first-hand knowledge between you and your mom. Let's go. We're going to talk about irrefutable evidence, right? Now, The definition of irrefutable evidence is something that is impossible to prove wrong or cannot be denied. So, when you reconstruct your affidavit between you and your mom give her intent on how, right? They showed you knowingly, right? It says intentionally, knowingly, right? Intentionally and knowingly, right? This is why I say we got to be in the knowing. So you and your mama know y'all intent, right? So you get to reconstruct this and put it on the record as evidence and know, and it's going to be what? Irrefutable. They can't even disprove it. So let's continue to go, right? Now let's go over the rules of evidence, right? Let's go over the rules of evidence as we're going to break down some of these rules, and we're going to talk about rules of general rule of competency, right? Every person is competent to be a witness except as otherwise provided by these rules. Now, disqualification of a witness in general. A person is disqualified to testify as a witness when the court determines that the person is incapable of expressing him or herself. I'm not going to go through everything. Incapable of understanding the duty of a witness to tell the truth. A spouse testifying against another spouse. A crime against testifying spouse or child, right? To testify, spouse elects to testify. The testifying spouse elects to testify. So the judge can disqualify your spouse. An officer while on duty for the exclusive or main purpose of enforcing traffic. A person giving expert testimony. A person testifying in license to practice medicine or surgery or some type of medical practitioner. These are expert witnesses. So I'm not going to go through everyone, but I just want you to see, right? So the evidentiary standard. So oath and affirmations, lack of personal knowledge. A witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. I'm not going to go through everything, right? Okay, evidence to prove personal knowledge but need not consist with the witness on testimony. The rule is subject to provision under 73 relating to opinions, 703, opinions testimony by expert witnesses. So we got to understand now, expert witnesses are experts in their field of study where they could talk about particular information. They don't have to have first-hand knowledge, but they could talk about how evidence can be presented and how they found certain things relating to certain information. Or like, let's say somebody got shot, they could talk about the gun wound, how it went in, what organs did it hit, how did the person die, and stuff like that. Like if it hit a lung and the blood filled up in the lung, that's what caused the person to die and stuff like that. So it says basis of opinion testimony by experts. The facts or data in a particular case upon which an expert bases an opinion or inference with may be those perceived by an expert or admitted into evidence at hearing. Okay? Let's go back. Let's go continue. It's a lot of stuff. I'm trying to not overlook some of the stuff that's important. Let's go through hearsay. Let's go through the hearsay rule. Let's go through that. It's a couple. What was that? Let's go here. Lack of oath. Before testifying, every witness shall be required to declare that the witness will testify truthfully by oath and affirmation, and administered in a form of calculated to awake the witness conscience and impress the witness mind with the duty to do so. Okay? So everyone must take an oath or affirmation. You don't have to take an oath, but you can take an affirmation, right? Let's go to, let's talk about opinion testimony by a lay person. This is very important. Opinion testimony by a lay witness. If the witness is not testifying as an expert, the witness testimony in the form of an opinion or inference is limited to those opinions or inference which are rationally based on the perception of the witness and help to clear understanding of the witness testimony or determination of facts and issue. So this is very important as a layman to when what he attests to and how the courts look at his testimony. Now, we're going into, I'm not going to go through all of this. Let's go through the hearsay rule. Let's go through the hearsay rule. Hearsay is not admissible except as otherwise provided by the Constitution of the United States and by the Constitution of the State of Ohio, by statute enacted by General Assembly, not in conflict with the rules of the Supreme Court, by these rules or other rules prescribed by the Supreme Court. So, okay, I want you to understand that, right? This is the hearsay rule. Now, you got to understand the rule. The following definition apply under these rules. A statement, an oral written assertion or nonverbal conduct of a person, if it is intended, everything is intent by the person as an assertion, declaration. A declarant is a person who makes a statement. Hearsay, a statement other than one made by the declarant while testifying at trial or hearing offered in evidence to prove the truth of the matter asserted. Statements that are not hearsay. A statement is not hearsay if, one, you got to witness, right? I'm not going to go through all of this because I'm trying to keep this video short. Y'all have to understand this. So, we're going to go down to we're going to go down to here. Authenticating, requirement of authentication or identification. So they're going to tell you general provisions. The requirement of authentication or identification as a condition precedent to admissibility and satisfied by the evidence sufficient to support a finding that the matter in question is what is purported to claim. You got to know these rules if you're trying to present evidence. They teach you how to set up and administrate your estate. They got illustrations, testimony of witness with knowledge, so you got to understand that. Non-expert opinions on handwriting, okay. Distinctive characteristics and the like. Comparison by trial or expert witness. Voice identification. Telephone conversations, right? Public records and reports. This is very important. Evidence that a written or authorized by law to be recorded or filed, in fact, recorded or filed in a public office or purported public records, report, statements, and data compilation in any form is from the public office where items of this nature are kept. This is very important. Y'all got to understand this rule right here. So, ancient documents, I think I'm going to stop and go. I'm going to start here on the other video when I do, and then we're going to go to self-authentication, right? And I really want you to pay attention to 3. I want you to pay attention to 3. Okay. I want you to talk about 4. Pay attention to 4. I want you to pay attention to 5, 6, right? We're going to say 7. I want you to pay attention to all of these, right? Okay. I want you to pay attention to all of these, right? Pay attention to this. So this is King L Bay. I'm gonna start over with the self-authentication, but this is the video that you need to watch. I'm trying to keep these videos real short and sweet. Peace and love, family. I'm out.